Afternoon again, everyone. Thank you for making the time. I think we can now start. Whoever joins after this can get us on the way. Thank you for making time. This is our second seminar in a series of 3 seminars. As per the title, the overall theme is recent developments in South African environmental law. In our first seminar, we assessed these developments through the eyes of the court. We picked up few more recent cases and what they meant for all of us. And today we're focusing on a specific topic, developments in climate change regulation in South Africa. And as you will see shortly as we go through further down, that there's been quite few changes, or at least developments in regulation of climate change in South Africa. For those who don't know me, I'm Wandisile Mandlana, as reflected on the video, a partner at the firm in the environmental, natural resources, public law practice, specialized both in natural resources and public law and government contracting. With me is Carmen Bradfield, who I've worked with for a few years now. She is an associate in the same department and focusing or specializing largely on environmental law and parts of public law. And the way we have done this presentation, she will take us through the first session, which is the bulk of the presentation. And I will come at the end with few of our perspectives. If I could just, before we focus on the topic, just few other housekeeping matters. As I said, we really appreciate you taking time to join us. Thank you for that. We've planned this to be quite interactive as the previous sessions. In order to interact with us, you can post your questions on the chat. I think the chat is open. If the chat is not opened, you can use the question and answer session. And as the moderator, I will be monitoring those questions and comments. And any that comes up at any stage, I will then raise with everyone. For example, I can see Paul's ones. Thank you and good afternoon, Paul. And I've seen Carmen's response. That's how we're gonna play it. From time to time, I will pause and ask Carmen to stop if there is an immediate question or comment that comes up that requires attention. So that is how we are planning to do this. Before I hand over to Carmen, let's just re-emphasize as the specific topic now, we are looking at specific developments under South African law in respect of emission reduction measures. This is quite an important qualification, as you would know, if you involve in any aspect of climate change action. There's few moving pieces, some of each technical, some of each legal, and some of them regulatory. And today we're not focusing on the broader climate action developments, but focusing on a particular specific aspect in the regulatory field, those developments relating to emission reduction measures. Other parts, as it will become apparent that you can't avoid them completely, I think it is one area that will show to many that you could collaborate across disciplines in solving this broader problem, and we're just trying to bring across few of our thoughts. And at this stage, then I'll invite Carmen to take us through on this specific topic before we go back to conclusion and answering questions in the interim. Thank you.
Thank you very much, Wandi, for that kind introduction. Hello, everyone. I'm Carmen, and I'm absolutely thrilled to be here with you all today. As Wandi indicated, we will make sure that the presentation is available on the website, and a recording will be available there too. So I'm going to jump right in, and I'm going to start with an international overview which really just reflects the nature of the targets that have been presented by various countries across the world. And as you can see from the giant grey area, there is a lot of commitments which still need to be made in order to address climate change issues, and particularly to get to a 2-degree scenario. So why is this important to us? Well, it's important to us not only because of the numerous socioeconomic risks that climate change poses, but also because there are inherently a ton of physical risks and a number of people that will be displaced due to these physical risks and the nature of climate change. In addition, we have very clear financial risks which impact us and which need to be taken into account in order to address climate risks and climate change issues. And obviously, from a commercial perspective, stranded assets is also a very real threat and may result in developments not coming to fruition or to financial close. So if we have a look at the international developments, the United Nations Framework Convention on Climate Change was really the starting point for the international developments and came about in the early 1990s. South Africa became a party to the UNFCCC pretty early on, which is quite remarkable considering it was very much still in its developing phases as a country. We acceded to the Kyoto Protocol in 2002 as a result of the threats faced by GHG emissions. And under the UNFCCC, we saw the very clear introduction of the 2-degree scenario, which we've all talked about and know about today. The Kyoto Protocol has resulted in the development of the Clean Development Mechanism and has encouraged South African policy developments. We also became a party to the Paris Agreement in 2016, and this resulted in a very clear need for domestic legislation to be developed in order to give effect to the commitments about the reduction of greenhouse gas emissions. And as you know, under Paris, there are nationally determined contributions which countries can attest to. South Africa is a non-Annex I country, which means that we have a recognition as an undeveloped country or a developing country. And it really acknowledges the difference in the commitments that are able to be made by developed versus developing countries. And both of these agreements do recognize common but differentiated responsibilities across the board. So despite us making great strides in terms of becoming parties to these agreements and developments, we very much are still not where we need to be, considering that we're still the 14th largest emitter in the world. And per capita, our greenhouse gas emissions are really quite astronomical as compared to other countries. So if we look at our domestic foundation of climate change, the key driver for us is really Section 24 of the Constitution, which recognizes that everyone has a right to an environment which is not harmful. In conjunction with this, we have the white paper on the National Climate Change Response. This forms the overarching guideline for our South African response, and it indicated various methods and instruments to reduce greenhouse gas emissions. Ultimately, it was decided in the white paper that a carbon tax would be the best way to incentivize people to reduce their greenhouse gas emissions. And now we have the Carbon Tax Act, which we all, I'm sure, know about, but which we'll touch on a bit more later. There were a number of other legislative measures to reduce greenhouse gas emissions, which sit within the Air Quality Act and which were also recognized in the white paper. And I'll go through these in a bit more detail too.
Maybe before you just go through a little bit of detail on this, Carmen, if I could just make 2 comments. In the first instance, just want to let everyone know that within the participants, we also have Michael Vermaak, a partner in our team. So we have more people to field your questions. If I just, on the point that you have just made, which is, I think is quite an important thing, on the 2 things that you've just shown us, you've shown the international foundational basis of climate change regulation across the world, and we have zoned in into South Africa. And in South Africa, there's 2 instruments you've just fleshed out here. The Constitution and the white paper are quite important and need to be borne in mind in whatever you do that may impact the environment or have implications for climate change. And as we will show shortly, in respect of these specific legal instruments, that the interpretation or understanding on what the Constitution and white paper provide for becomes important and a running theme across. Thanks.
Thanks, Wendy. That's great. And it is a very important point. It really is the fundamental for us to work off of. So if we move on then to the Air Quality Act, as I mentioned, there are various instruments under the Air Quality Act which assist in us reducing or getting to a point of at least knowing what our greenhouse gas emissions look like. So the most important instrument in terms of a licensing perspective under the Air Quality Act is an atmospheric emission license. And this assists with the general protection and enhancement of the air quality in South Africa, because you need an atmospheric emission license to conduct listed activities. And these licenses must specify point source emission measurement and reporting requirements. And so you are always required in terms of your atmospheric emission license to fulfill some kind of reporting duty under that license. And it's of the utmost importance that you make sure that your atmospheric emission license covers your full production process. We often see instances in which the production process isn't fully covered, and that leads to difficulties because ultimately that's a contravention of the license and of the Air Quality Act. So that's one of the mechanisms that we use. In addition, the Air Quality Act introduces the National Ambient Air Quality Standards. This too was recognized in the white paper. And what it does is it identifies substances that are a threat to health, well-being, or the environment. And it includes indirect GHG emissions. These are also referred to as minimum emission standards, or the MES. And recently the MES has been increased for solid fuel combustion installations to 1,000 milligrams. And you would have seen that there's been a bit of litigation around this about whether it was prudent for government to increase this minimum emission standard, and whether in fact, companies should have been brought into compliance with a lower threshold. But in terms of the litigation and what's gone on, the 1,000 milligram threshold still remains. Wendy, I don't know if you want to jump in on anything there.
No, thanks. I think the emphasis again there is that the law as it currently stands, which I think it will come quite late when I go to the point when we show trends, that in this policy making, you've got few competing interests, the regulators, the industry, and the civil society that must be reconciled. And ultimately, I think everyone, what they are working towards is a common goal, and then these competing interests must be balanced because they've got implications for everyone.
That's great. Thanks, Wendy. So the additional measure we have under the Air Quality Act is the declaration of priority air pollutants and pollution prevention plans. So greenhouse gases are priority air pollutants, and recently the list of priority air pollutants has been amended. The pollution prevention plans are required to be approved for activities which are listed in the regulations, where more than 0.1 megatons of greenhouse gases are emitted annually, or as directed by the minister. And in terms of these pollution prevention plans, as many of you I'm sure know, you have to submit an annual progress report, and the initial report was required in 2018. It's done in a 5-year block, and this is intended to align with the carbon budget provisions, which will be introduced under the climate change bill. There is a bit of a disalignment in terms of the timing of that 5-year block, but we're sure that it will be addressed in due course by government. It's an offence to fail to submit a PPP, and you can be fined up to 5 million rand in the case of a first contravention, or imprisoned for 5 years. If you're required to have a plan, then you also need to have it approved, and as I said, submit annual progress reports and meet the obligations in terms of that plan. It's anticipated that pollution prevention plans will be included as gas mitigation plans under the Climate Change Bill, which Wandi will also touch on a bit later. So here's our brief overview of the Air Quality Act obligations. We've talked about greenhouse gas reporting, atmospheric emission licenses, and priority air pollutants and triple Ps. So the big change that we've had recently, well, last year, is the Carbon Tax Act, which was introduced. So initially, drafts of the bill were provided in 2017, and it was anticipated that the tax was going to come in a lot sooner than it did. But it's here now, and what it does is it gives effect to the polluter pays principle. The liability under the Carbon Tax Act depends on the carbon intensity of a business or a business unit, as well as the plan to transition to a low carbon economy and your current emission levels. So originally you would be taxed if you conducted an activity in South Africa, and that is listed, if you exceeded the threshold stipulated. But now you are, in terms of the Taxation Law Amendment Bill, you are taxed if your greenhouse gas emissions are equal to or exceed that threshold. This is quite an important thing, and in terms of the greenhouse gas reporting regulations, it's a very important aspect that your greenhouse gas reporting is now done in terms of meeting or exceeding the threshold and not just exceeding that threshold. This is quite a recent amendment and does try to bring the two acts together. So tax is levied at a rate of 120 Rand per tonne of carbon dioxide equivalent of the greenhouse gas emissions of a taxpayer, and it's levied in respect of greenhouse gas emissions from fuel combustion, industrial processes, and fugitive emissions. Currently, that rate will increase by CPI plus 2% in the first phase and by CPI thereafter. But it is anticipated both locally and internationally that tax rates will increase astronomically on CO2 emissions. In some areas, the projection is that CO2 per megaton may cost as much as $500 per ton. So under the Carbon Tax Act, you do have allowances in terms of which you can reduce your liability. Wandi, did you want to jump in?
Now you can conclude that thought. We've got a question on air quality. We'll go back to it.
Okay, great. So in terms of the various allowances that are available, initially there was a bit of a discrepancy in terms of your cumulative amount of allowances not being able to exceed 95%. In some instances where the basic tax-free allowance was actually 100%, this is now been rectified in the Carbon Tax Act. So a basic tax-free allowance applies where it's specified in the schedule. It may range between 0 to 100%, but typically is in about the region of 60% for each activity. And it's available for a number of activities, including for fuel combustion emissions. Industrial process emissions allowances are also available. These are for industries where you're producing things like ferroalloys and aluminium and that kind of thing. Then a trade exposure allowance is also available for the sectors that are vulnerable to international competitiveness. So this is done on varying scales. So if you have less than 10% as a total calculation, then the trade exposure allowance doesn't kick in, but there are various degrees in terms of the calculation that you can work out. A performance allowance is there for every business that's outperforming in its sector and is implementing initiatives to reduce their greenhouse gas emissions and is proactively taking part in doing that as compared to the rest of its sector. The carbon budget allowance is available for those who partook in the initial voluntary phase of the carbon budgeting program. And an offset allowance is available for accredited projects. So where you've invested in appropriate carbon offset programs and you've gone through the registration and verification process under the offset regulations, then you'd be in a position to qualify for this offset allowance. So this offset allowance is meant and intended to give some kind of recognition to those projects which fell under the clean development mechanism, as we mentioned before, which was developed under the Kyoto Protocol. And there is a verification process to go through in order to have those programs converted and that kind of thing. Initially, we had hoped that there may be a bit more of a trading scheme, an international trading scheme, along with offset allowances. And it seems that at this point, what we have is what's contained in the offset allowance regulations. And I don't think there are any big plans to change that at the moment. Wendy, should we address the query we had on the Air Quality Act?
Yes, I think that's the right time to go back to it, because as an instrument arising out of Air Quality Act, but maybe if I could just share one observation on the point that you have just highlighted is, I think in the last 12 months, we have been quite uncertain as a country on how the carbon tax is going to function. But maybe to government's credit, recently, they've now put in all these measures in place. The test now is whether they perform to the level they were designed for, which for us, it is part of how the law on climate change is developing, that it is advisable that it is not passed in phases. If, for example, when you go to climate change bill, all instruments meant to support and implement it should be in place by the time the act is finalized and considered together at the same time, which was not the case with the Carbon Tax Act. On the air quality, thanks, Mbali. Are these questions are visible to everyone so that I don't repeat it? I think they're visible to everyone. Basically, I agree with you. There's quite few interesting
points. No, they are not visible to everyone, just the panelists.
Oh, sorry, thanks. So Mbali is asking on the Air Quality Act. She's asking in the first instance whether we all are aware of the high priority areas as provided for in the Air Quality Act, which needed government release the plan around the plan around to reduce air pollution in the high priority areas, and asking whether or observing that this plan has hardly been implemented, and then posing a question which probably would be open to everyone should we have a chance to debate it further, whether does government have enough finance to implement this plan? Does it have financial means to tackle climate change generally? And then the other part of that question is whether as a country we are meeting our obligation to get financing from developed countries per international law. That is the question. From our perspective, there's few things one can say on this. Indeed, you're right, we have had this high priority areas concept, but it is important that we just consider what it was meant to do. In the first instance, as you rightly say, that it was to identify those areas, its air quality was below our national standard. And because when really sure of the impact, A was more to create a reporting obligation if you are within a priority area. And secondly, was to sort of, if you are within a priority area, you are able to be required to produce or indicate your pollution prevention plan, and it be assessed as part of your licensing exercise. I do think, based on experience, that whenever you are proposing a new development or expanding or optimizing an existing development within a high priority area, the mitigation measures one proposed for air pollution taken quite seriously as part of the licensing process. So as a planning tool, I do think it is serving partly its objective. And as we demonstrate further down the line, or as you, which I'm sure that is your experience too, that when it comes to pollution prevention, be it air or other environmental medias, it is really not a government issue, but all stakeholders. And I've seen many corporates doing quite a bit on ensuring that these are complied with. Where the government has financial means to tackle climate generally, it's always that objective test. It is competing with other interests, and the requirement under the Constitution is just progressive realization of environmental rights. And I think we've seen quite a bit government doing in this regard. Whether we're succeeding, it's really, I think, what is it, a more qualitative assessment, which the lawyer in me cannot really do much of it. But from the statutes and from the policy making, I think whilst we're not at the optimum position, we are getting there. Maybe by way of reflection, if there are any other one or two participants who've got a perspective on this, what I will do, you could write your answers, then I will open your mic to share that thought if you have any other thoughts. Thanks.
Thanks, Wendy. I think you've put that really well. And I think one of the important things to remember is that there are still instances of litigation in high priority areas related to people being impacted by the, quality of air in those areas. So as Wendy said, it really is important for us to keep in mind what the intention was behind that declaration as a high priority area. And in terms of the financing aspect, there was in the past quite a bit of debate about whether the amounts which are paid under the carbon tax should be ring-fenced in order to assist in addressing climate change needs. And it is an ongoing consideration of whether there is enough financing to do this. But ultimately, the decision was made that because the amounts that would be obtained through the carbon tax would not be sufficient to assist in developing really great programs in addressing climate change needs, that it would go into the general treasury pot in order to be administered and used in that way. So it is clear from that kind of thinking that there is a focus, I think, on trying to make sure that government has enough finances in order to meet these types of ESG issues. Okay, so I just want to take a bit of a step back to the greenhouse gas reporting under the Air Quality Act, because there really was quite a bit of a discrepancy between what you were required to report on in terms of the Carbon Tax Act, which required you to be liable if you met or exceed the threshold, and the greenhouse gas reporting regulations had, when that amendment came in, not been amended to align with that. And I just wanted to take us back to that requirement. So under the greenhouse gas reporting regulations, we know that data providers must register. These include, those who have operational control and all holding companies and subsidiaries. So where you're exercising control in the form of being able to implement policies and manage a facility, then you are required to report. The reporting of activity data was amended in this year due to the COVID crisis. And one of the other aspects that is important for us to consider is that this information is used to verify your carbon tax liability. And so when we talk about reporting under the Carbon Tax Act, there is a bit of a discrepancy for the first tax period, but the reporting period for greenhouse gas emissions and reporting for purposes of the Carbon Tax Act. So if we look at how the Customs and Excise Act comes into this, is the carbon tax is levied as an environmental levy through the Carbon and Excise Act. And it requires that you must pay your carbon tax and submit your environmental levy accounts, generally by July. This year, again, a bit of difficulties around the COVID crisis. And all warehouses and facilities where emissions are generated must be licensed. This is quite an important consideration in terms of ensuring that your facilities have the correct licenses in place. And it is possible to obtain a consolidated license for all your facilities, and no license is required where a basic tax-free allowance of 100% applies, or the tax threshold is specified as not being applicable. So you submit a consolidated annual account, and the first tax period was from the 1st of June 2019 to the 31st of December. As I said, the greenhouse gas reporting period doesn't align with that. So some taxpayers were facing a bit of a difficulty in terms of making sure that the emissions reporting system aligned for purposes of going through the carbon tax process. So importantly, SARS's online platform is now open, and everyone should be sure to make sure that they have the correct licenses in place and have submitted their annual accounts by the 31st of October. So if we have a look at our summary of legal obligations, we've talked about the requirement to register as a data provider, the reporting that's done through your annual greenhouse gas reporting, developing a pollution prevention plan, submitting an annual pollution prevention plan progress report if you're required to, obtaining an atmospheric emission license, and licensing your emissions generating facilities as manufacturing warehouses under the Customs and Excise Act. So here's a snapshot of our legal developments in 60 seconds. We've talked about our international obligations and the Kyoto Protocol, which ultimately led to the development of our white paper. And this in turn brought about our Carbon Tax Act, in terms of which we have our liability, but can reduce it through various allowances. It's administered through the Customs and Excise Act as an environmental levy. And under the Air Quality Act, we have pollution prevention plans, greenhouse gas reporting, priority air pollutants, and atmospheric emission license. And as Mbali has said, high priority areas, I suppose, could go in that little bucket too. Hi, Wandi.
Two systems. This is not, the GH reporting does not take place through the NACE system, but the okay. So maybe Carmen, you can drive it your side. I'm lost. I think I've lost how to request control from you. So basically what we're getting to, the session we're getting into now, is to now we're sort of largely articulating the international and the domestic legal position as they exist, and has come and done towards the end. Under the different baskets, we have identified what the obligations are. We have considered under the Air Quality Act, what are the obligations or what the regulatory instruments they are and what the obligation one has to meet. Under the carbon tax, what the obligation and who carries that obligation and the administrative processes of carrying out that obligation. And those were the obligation, legal obligations, and those are the law as it exists. And what we are now turning to, it is some other key developments in developing in developing climate change legal framework in South Africa. And this is largely broken into two parts. where we look at legislative developments and non-legislative developments and other initiatives. I think notable at the legislative development front, which we all are aware, it is the climate change bill that was published a year and a half or two ago, which would be a specific climate change legislation. And this is a welcomed development, and it's consistent with many countries now in the world, where climate change is not simple throw away in one of the legislations, but the focusing is on the climate change. As I say, although this was published a year or two ago for comment, and nothing really in public has come out as to where the status is, but at governmental level we've seen some further movement. For example, the Presidential Climate Change Coordination Committee, which is going to advise on climate change matters, response mitigation, and all of that, and coordination, was recently announced, I think now in July, which shows some further movement. And some, from that bill, what was becoming clear were few of the instruments that may be used, but as I indicated earlier on, that whilst it gives an indication of where the law is going, the difficulty most people have had with the bill itself is you've got the bill and it is being considered in isolation to, we don't have the regulations themselves so that we can further aid the implementation or how to interpret or assess the impact. What we largely have are concepts. Like, for example, as we're mentioning, pollution prevention plans will now be treated as GHG mitigation plans. And then it is focusing the bill on establishing a few institutions like the Ministerial Coordination Committee, and it will provide for setting sectoral emission targets. The methodology and how that will be done is not readily apparent from the bill itself, which are where then on the development front, it suggests that there's still more work to be done. But as a starting point, the fact that we are now thinking and working towards having a specific climate change bill or act when it comes into force is a welcome development, which brings us into line with most recent developments across the globe. If we can go to the next. And which is, so as we're saying, what we're really part of it, you'll recall in the beginning, that one of the points that we highlighted, why is this all important? There we consider that its importance both as a social consideration, as an environmental, and as an economic consideration. And as we're saying, there's quite few opportunities in transitioning towards low carbon. And we have seen a number of these initiatives, both in the market, governmental level, and really civil society and the corporates. Among notable things that we are seeing quite a bit of concerted movement on are, for example, we all know about South African Renewable Energy Independent Power Producer Program. It had halted for a few years, but by all indications, which is through the Section 34 determination and other pronouncement, it looks like it is coming back. And Schedule 2 to the Electricity Regulation Act was recently amended to provide for more people who may generate electricity without obtaining an electricity generation license. And as you see, most of those are all likely to be coming from renewable energy, and which is quite an important exercise. And as I say, different initiatives are being implemented across industry. We're seeing quite an increased activity in other initiatives like clean hydrogen and other mitigation measures various entities are adopting. So all we're saying is there's few quite opportunities available there to be explored in our all quest to transition to low carbon economy or carbon neutral economy at some point in future. If you go to the next.
Wendy, we've got a great question that's come in. Chris is asking, so the climate change bill is a SEMA. Please elaborate on what exactly this means and how this has affected its drafting. Thanks.
Do you want to take it?
Sure. So a specific Environmental Management Act is what Chris is referring to. And what this means is that it falls within the bigger suite of our environmental laws, in that the provisions that are included in NEMA apply to specific environmental management acts in terms of various considerations. So for example, penalties being imposed or stop orders or compliance notices and that kind of thing may apply in accordance with it. And it means that the climate change bill, once it becomes an act, will fall under the National Environmental Management Act, as the Air Quality Act and other specific environmental management acts do.
Thank you. And that requires some. Sorry, yes. I was saying then that requires some planning for this legislation when it finally comes into play.
Yeah, it definitely means that we need a bit more clarity on the regulations and how they apply and work together with those provisions.
I think we've been moving between topics. So essentially what then, as we have mentioned, there's quite few activities on the go by all stakeholders. On the non-legislative developments, the really key driver, among others, has been the activism around climate change led by civil society. And outside civil society, which may be in another guy's civil society, you've got shareholder activism. You've seen a few of the annual general meetings in the last few years, companies being taken to task on their climate change impact and planning scenarios. And that has forced companies to really, which they've always been doing, but to account more on their climate action. And part of how civil society is seeking to drive or is driving its initiative is through request for information. It is requesting partly, as I was saying, your climate change position, your climate change exposure, and what you're planning to do. And through their own scenario planning, they then report or produce the publicly available reports on their take on how the industry or the market is performing. One of the things which we have spoken about in the past, which is a key development we must never lose sight of, going into the future, we may see, depending on how we really respond as government and as industry, that we may see a rise in potential claim for damages. But as we'll show when we come to litigations like just below, that whilst in other jurisdictions that is already a reality, in South Africa, it's not yet materialized. Here, Sasol and Standard Bank are just specifically mentioned because of their transparency on, not only Standard Bank, all banks, of their transparency on what they are doing in regarding climate finance and all other, and they were quite on the news, particularly both entities on how shareholders in successive AGMs in the last 2 years raised pointed questions, which the boards of the companies had been looking into, which just shows partly on how civil society and shareholders working together can achieve a social objective. I will pause here and say, I think I saw a question popping up from Vicky. I know, Carmen, we chatted about this point this morning. Do you want to take it? You on mute.
Sure, thanks, Wendy. Drinking penalties should be imposed for muting a Zoom call. So TCFD principles and principles for responsible banking investments and these kind of voluntary disclosure programs are definitely on the uptick. And so we have seen that most banks, in fact, have adopted the TCFD principles, which is fantastic in terms of reporting. So for those who don't know what TCFD is, we're talking about the Task Force for Climate Related and Financial Disclosures. And it basically encourages the proper disclosure and reporting and assessment of financial exposure in respect of climate change risks, as you would take into account other financial risks in terms of your developments and policies. So we've definitely seen that there's an increase in this, but as a legislative matter and mandate in South Africa, we certainly don't see the same kind of financial disclosure requirements being imposed in terms of the law as yet, as we do in other jurisdictions. That doesn't mean that there isn't a great push for it. We have many and know of many people who and companies who are involved in the climate disclosure program and which do the annual reporting, etc. And that information and the taking into account of these financial risks in terms of climate change is really of the utmost importance to ensure that your ongoing project and company and from a responsible investment practice is used and utilized as best it can. The more information you have and the more you account for these types of risks, the better for the business, the better for your shareholders, and the better for your company as a whole, because it also assists in avoiding that kind of stranded assets development further down the line. So thank you for that, Vicky. That's a great thing that you've highlighted for us.
And as we all know at the moment, one of the key, not global movements, but one of the developing trends, it is this whole concept of sustainable investment. And that is a key consideration in any sustainable investment initiative. And then what I see Vicky is saying, more than it being a question, it was more of a comment, which I think we really agree, sort of re-emphasizing that thinking that there's quite few initiatives on the go relating to carbon disclosure or climate disclosure risks on the go. Tulele's question is whether are we aware whether there's been any prevention of any financial clause as a result of civil society action. I wouldn't say non-financial clause as a result of civil society action, but it is the next exact slide, maybe, Carmen, if you go to the next slide where we're going or not, but there is, yes. So not simple as a result. So what happened, as you may be aware of, that about 2-3 years ago, 3-4 years ago, that's how time flies, government started the independent power producer program, a coal-based program, where it was seeking to buy from independent power producers coal-fired stations. And key of those, some of those projects which are publicly and widely reported relate to the Thabametsi and the Thabametsi power station, or the proposed Thabametsi power station, which for a time has been challenged, or the environmental authorization has been challenged for failure to properly or adequately consider environmental impacts, especially climate change. And there've been all sorts of to and from internal appeals, reviews, and all of that as to the inadequacy of that. Because that is ongoing, for example, there were internal appeals went to review the decision of the minister, came and that was reviewed and set aside. I mean, the minister was referred back to the minister who on internal appeal took a similar decision, and then that has been again subject to an ongoing review. Whilst that is happening, there can be no financial closure. But I think what is telling in that case is all parties involved have moved miles from where they started. All of them, be it government, be it the entity involved, and be it the civil society, have worked towards at least trying and establish a methodology of undertaking this climate change impact assessments, how they will be taken through decision-making process. Once that is clear, then you would see it being just done as a matter of course. But yes, in these two particular programs, financial close has been delayed as a direct consequence of these pending legal challenges. What we wanted then, as part of that answer, wanted to demonstrate with these cases is we're starting to see in South Africa quite a bit of action in litigation, but in South Africa, the litigation we're starting to see, maybe you can go just back, comment with the stats. The litigation we see in South Africa is largely concentrated on suits against government decision than individual corporations as a claim for damages. Whereas elsewhere in the world, you're starting to see people claiming for damages as a direct consequence of climate change impact. In the past, we have looked into the reasons why that may be so in South Africa. And clearly, one of the key things we came out with were issues of law or legal nexus causation, that there may as well be some difficult to show that causation. But be that as it may, an attack on a government decision, an attack on your license may have an impact on climate change, which goes to that ultimate goal that climate change action is a key consideration in conceptualizing, planning, and implementing any development project. Without that thorough consideration of climate change impact, then the project may run into troubled waters, because that is quite a focus of many stakeholders on how this is handled by a company. If not civil society, potential investors will look at it quite seriously, which means, as I say, has to be taken into account in planning and implementing the project.
I think that's such an important point you touched on, Wandi, because I think we definitely have seen an increase in people starting to use the interested and affected party routes and appeals under NEMA, that kind of thing, as a mechanism in order to challenge the aspects around climate change in licensing processes for projects.
Yeah, thank you. I think that sort of just brings us to the end of, do you mind covering these trends so that I've moved between topics and I lost? Do you want to cover these trends? Yeah.
I'm happy to. So we just wanted to give you, we've touched on it quite a bit, and Wandi's touched on quite a bit of it throughout actually. So internationally and in South Africa, we are seeing increased pressure from civil society organizations. And in South Africa, as I mentioned specifically, we're seeing an increase in the use of appeals and reviews processes in order to challenge aspects around climate change. Internationally, as Wandi mentioned, we're seeing litigation against government and corporations, and instances where people are trying to institute claims for damages. There is a difficulty in proving causation in that, and as the science develops, I'm sure we'll see an uptick in that as we carry on. And so internationally, we've spoken about the fact that direct financial disclosure obligations apply for many companies on stock exchanges. In South Africa, our legislation is not as advanced as yet. There are specific requirements in terms of the Pensions Funds Act, and when you're making investments relating to pensions, which is really important to take into consideration. But we're very much more at a rudimentary system, level of our legislation being developed. Internationally, we've also seen that there's been a big uptick again in the talk around carbon trading and international trading systems like the EU ETS. In South Africa, we're a bit more limited on that. And we're not really at the space where we have the mechanisms to compete internationally or trade internationally on that level. So in South Africa, we also have the potential for class actions. It is a possibility under our legislation if the requirements of it are met, but it is a process to go through in order to institute a class action. But we're sure developments will see that eventually.
In the 1 minute we have remaining, maybe just to quickly reflect on Vicky's question. Internationally, we have, so it differs from jurisdiction, or in the chart, what Vicky is asking whether we have seen these class actions against asset managers and insurers. What I just want to reflect briefly there, what we could share, there's a study we have been doing for the UNPI program, United Nations Program on Investment, which is looking into this sustainable investment, and its various law firms participating, and we're dealing with the fresh fields overseas. And what is coming out quite clearly that it differs from jurisdiction to jurisdiction. And the level of exposure for asset managers in the main is at the moment true, at the moment is largely true claim for insurances than an insurer being liable as the cause. So whoever is found liable would claim against their insurance, and then that's where the insurance companies are exposed. Under South African law, as you know, we can't at the moment, and as the law currently constructed, immediately see that exposure for asset managers and insurers because they sit way above, in most instances, the project company or the investing entity. So those are all considerations, but as we are saying, the investors into those entities look into the climate action or climate change approach of any company they invest in. And I do see Rolf's comment as well. We agree that these appeals can cause financial close delay. Thank you for everyone. We are set to stop at 1. That is always the difficulty with these webinars, is you can't sit around the table and chat more about these questions, but really thank you for making time. And as we said, these slides will be available later today, and happy really to field any questions anyone has post this webinar. And yeah, of course, whilst we're willing to engage, it is not written opinions. We charge for written opinions. Thank you.